Villiers and Villiers.
This is, my ladies, my lords. I've thought about my position overnight. I touched fairly briefly on issue 3, the Villiers issue, yesterday. I left open the possibility of returning to it, but on reflection, I think my time is better used on other matters, so I'm going to leave Sir James to deal with that. What I propose to do in the hour, which I look up at the clock, but it's stopped. What I propose to do with my remaining time, and I think I may well not even use it all, is to go back to make a couple of fresh points in relation to issue 2. That will then lead naturally into the unrelated actions point, which is raised by the intervener and which obviously overlaps with issue 2 significantly, and I shall then go on to deal with issue 4. So if I can just revisit issue 2 briefly. There was, in a sense, a debate yesterday with my learned friend Mr. Horton saying, well, there's no express removal of FNC in Schedule 6, and me saying, well, there's no express retention of it. But it may be that that is a somewhat sterile debate, and I would ask the court to go back to one paragraph in the CPAG case, which I certainly didn't take the court to yesterday, though the court may have looked at it, and that is in Volume 1, Divider 11, and the report starts at 320, but we've looked at it in some detail, and I only want to refer really to one sentence, which is at page 337 in the judgment of Lord Dyson. We looked at paragraph 34, but I would draw attention to paragraph 35, where Lord Dyson said, I agree with Lord Brown that for the reasons he has given, Section 71 was intended to be an exhaustive code. And I would suggest that the court's focus should be on the question of whether Schedule 6, in our case, was meant to be an exhaustive code. And in that way, one sidesteps any questions of whether there is an express deletion or an express retention, and one simply treats it as an inquiry into whether Schedule 6 is meant to be an exhaustive code.
Could I just ask for your assistance with one point on Section 49, which is MS page 43, sorry, of the 82 Act. I was just puzzled why it refers to the 1968 Convention, where my understanding was that that's now been replaced by the Brussels regulation and then the Brussels recast. Can you help?
Well, my lord, can I say first that Lady Hale asked yesterday a question as, in effect, what is the overall purpose of Section 49? So to try to answer that, we have provided the court with a 2-page extract from Dicey, which does deal with the overall purpose of Section 49. And it has been sent electronically. But it deals with it specifically at 014, and I'll come back, Lord Sells, to your point. It says, Section 49, as amended, provides that nothing in the Act is to prevent the court from staying its proceedings on the ground of forum non-convenience or otherwise, where to do so is not inconsistent with the Brussels Convention, or as the case may be the Lugano Convention. As the regulation is directly applicable in the United Kingdom, it was considered to be inappropriate for the United Kingdom to make a similar legislative statement in connection with it, but it was never in any doubt that an English court would have the same power or lack of power to stay proceedings where jurisdiction was conferred under any of the 3 instruments. And then over the page, nor was it in doubt that the regulation or the conventions conferred jurisdiction on the courts of the UK where there was no power to stay or dismiss proceedings in favour of the courts of another member or convention state, except in accordance with the express provisions of the regulations or the conventions. So that, I hope, explains the overall purpose of Section 49. But in answer to the specific point about the Brussels Convention, my understanding is that it does still have, I can't remember the details, maybe Sir James will be able to help, I don't know, but I believe it does still have some sort of ghostly residual presence in some very limited context, to the extent that it is worth, that the drafters of the amendment thought it worth mentioning it. But it's a very limited effect, and obviously Section 49 is mainly dealing with the Lugano Convention or the 2005 Hague Convention.
Yes, I mean, it is just a curiosity, for me anyway, that in the Cook and Virgin Media case, so this is MS page 349, at paragraph, 32, Lord Dyson seems to have treated section 49 as though it included a reference to the regulation, but...
I'm sorry, my lord, I missed that.
It seems to have treated section 49 as though it included a reference to the regulation, but it doesn't. But it doesn't.
Because
you say the regulation achieves its effects independently.
Exactly. And the maintenance regulation achieves its effects from its face, rather than by any need to apply it via section 49.
Yes, thank you.
Whilst we're on the detail, can I just ask a question, I hope with a little more focus than I asked it yesterday, about section 16, subsection 4?
Yes, my lady, I was going to come back to that.
Well, I mean, don't answer straight away, but perhaps I can put the question and then you can answer in your own time. The theory is that the way in which the 2011 regulation worked was to remove maintenance completely from this 1982 Act.
Yes.
Yes. And to that end, there was a removal of the provision that there was originally in Schedule 4,
yes,
reference to maintenance. That's
yes.
where we've just got dots, but I've been back and had a look.
Yes.
So, that being so, why refer to Schedule 6 at all in Section 16, subsection 4?
Well, my lady, I would suggest that the answer to that is, first of all, that subject to in this subsection should be read as meaning save insofar as it is precluded by. And there are then the references to the conventions. But Schedule 6 is mentioned because although the maintenance regulation speaks for itself, and so that doesn't need to be excluded because that is of direct effect, so that is automatically excluded from the ambit of Section 16. But it might have been arguable if the Section 16.4 did not include a subject to the CJJMR, that the CJJMR did still have a link to the 1982 Act. And so in our submission, the purpose of including the CJJMR in section 16.4 was specifically to make it clear that there was no substantive link between this 1982 Act and the CJJMR.
One can imagine a lot more simple ways of doing that. If that's really what they were trying to do. One of the schedules is excluding things from the ambit of the Act, isn't it? I can't remember which, but there is, I think, a schedule to the 82 Act which is designed for that purpose.
Well, my lady, that's right. But of course, this is in a slightly different category because the CJJMR are tied to the maintenance regulation. The maintenance regulation is removed from the body of the Act. And so this was the way that was chosen to remove the CJJMR from the Act.
All right. Thank you.
So I think there's really only one other point, because my lord and my lady have raised actually two of the issues which I was going to come back on in any event. But the other point is this, that I made the point yesterday that we say, for reasons which I've already given and won't go over again, that when one considers whether Schedule 6 provides an exhaustive code, that it does so both on its face and supplemented by the explanatory material. And even if the court considers the explanatory material might have been more full in its exposition of the removal of FNC, nevertheless, I suggest the explanatory material does make it clear that Schedule 6 is intended to be an exhaustive code. But the clincher is this. I referred in my first preliminary point yesterday to the decision of the Court of Justice in Sanders and Huber. That was a case which dealt with the internal allocation in Germany of maintenance issues. And the Court of Justice said that national statutes dealing with the internal allocation of maintenance cases within the member state must be consistent with the goals of the maintenance regulation. And the goals of the maintenance regulation are specified in that case and in R&P as being, or as including, the right of the creditor to choose a court and the right of the creditor to choose a court which is in proximity to her, assuming it's a her, if that is what she wishes. So the CJJMR is domestic national legislation which does allocate jurisdiction in maintenance cases within the UK, and as such it has to be construed, per Sanders and Huber, in a way which is consistent with the goals of the maintenance regulation, as I've set them out. And
I thought the Huber case was far more focused. I thought the Huber case was homing in on the fact that Article 3 of the maintenance regulation talks about the court for the place where the defendant is habitually resident,
well,
not the court for the state in which the defendant is habitually resident. So in that particular article, the regulation goes further than the state into the places within a state.
my lord, yes.
And so I think it may be quite difficult for anybody to draw any wider conclusions from the Huber case.
Well, my lord, with respect, yes to the first part, but no to the second. Yes, because it is the point about Article 3 which opens the door to the Court of Justice having an interest in the question of allocation within a member state. But what the Sanders and Huber case says is that any such legislation must be consistent with the goals of the regulation. And so the Court of Justice in that case sent the question back to the German courts to consider whether the centralizing legislation was consistent with the goals. So, my lord, it's a two-stage process. The Article 3 point opens the door, but the conclusion of the court is much wider than merely dealing with the Article 3 point that your lordship has focused on. And of course, there's not only Sanders and Huber, but there's also R&P, the Romanian case, which makes it quite clear that it is the creditor's right to choose. And of course, this goes back to Farrell and Long. But the creditor has a right to choose. So if we take a hypothetical case, slightly different from the present case, let us suppose that you have a maintenance creditor living in Bodmin, who issues maintenance proceedings in the family court in Bodmin. I would suggest that it would be entirely contrary to the goals and scheme of the maintenance regulation that she might be liable as a matter of the internal allocation under domestic legislation to an FNC application saying that the appropriate court to deal with her application was not Bodmin, but was Edinburgh or Belfast. And it would completely, to allow FNC in those circumstances, would completely cut across the goals and the policy of the maintenance regulation. And this isn't a matter which goes just to how discretion should be exercised if FNC is available. It goes to the question of whether FNC is available at all. And I say it isn't for that reason, as well as the other reasons I've given. Would your lordship give me a minute? Oh, yes. Yes, and I'm reminded, of course, that another goal which is mentioned in the Sanders and Huber case is to limit costs and, again, the protective nature of the regulation towards the maintenance creditor. If she issues in Bodmin, then she, being presumed to be the weaker party, one of the reasons that she's entitled to pursue her claim in Bodmin is because it's going to be cheaper for her to do so than to have to go to Edinburgh or Belfast. So, my ladies, my lords, I think that leads naturally on to the issue which is raised in the intervener's case. And that's of course in the core volume. It starts at 2183, and section on unrelated actions starts at 2188, and the intervener, if I can put it this way, floats the possibility that FNC might have survived in relation to unrelated actions. And in their written case, at paragraph 18, they rehearse, I think it's fair to say, rather than advance, certain points which might be put forward for the continued existence of the power to stay on FNC grounds in unrelated actions. And I would simply say, looking at, in particular, at 8.18.2, that it suggested that it could be argued that Article 3 does not require the courts of a member state validly seized to exercise jurisdiction. It may provide, for example, maintenance creditors with a choice of courts with jurisdiction. Where
are you reading from?
I'm sorry, my lady. It's at the bottom of 2188. It's paragraph 18.2 of the intervener's case.
Thank you.
And this is not an argument being advanced by the intervener, but being put forward as a possible argument which could be advanced in relation to unrelated actions. And part of that argument would be known sequitur, that choice cannot be subject to the court concluding that it would be better on FNC grounds for another court with jurisdiction to exercise that jurisdiction. Well, I would say that that is not an argument which could be advanced, because it is clear from RVP, the Romanian case, that a court which is validly seized must proceed. And I said when I introduced that line of authorities that they cut across a number of issues in the appeal, and so they are relevant, certainly for present purposes, both to the second issue and also to this issue raised by the intervener.
But between 2002 and 2011, when maintenance was in the judgments regulation, forum non conveniens was there, underneath by section 49, to catch the cases not caught by Articles 28 and 29. So there was no problem about that. It's wider, particularly in the two respects identified by Mr. Horton, and there it was. So you're saying, well, this is quite inconsistent. It wasn't inconsistent with the judgments regulation. So you've got to say it's now become inconsistent with the maintenance regulation. And then you've got to say, and that actually also applies to the intra-UK situation, assuming, contrary to the arguments we're about to hear, that the maintenance regulation has no direct effect intra-UK.
Well, my lord, the alternative, of course, is that that if there had been a challenge to the regime that prevailed between 2002 and 2011, then it might have been found that the system which then prevailed was inconsistent with the goals of the Brussels I regulation. But whether one says...
Sorry, just on that, I thought that, again, it was the basis for Lord Dyson's judgment in Cook and Virgin Media that if there was inconsistency with the relevant regulation, that would exclude foreign non-convenience and other discretionary grounds under Section 49. The point was, in Cook and Virgin Media, that there wasn't an inconsistency because it involved an intra-UK case, and at that time there was no question of excluding foreign non-convenience in an intra-UK case. So
well,
I would have thought that the argument was that with the introduction of Schedule 6 to the 2011 regulations, if on proper construction, Schedule 6 has extended the exclusionary regime, which previously was only extra-UK, to make it apply as an exclusionary regime intra-UK cases, that would have an effect on the applicability of Section 49.
My Lord, I'm more than happy to adopt that formulation.
All right, thank you.
So that means that Schedule 6 has got to have extended the position to intra-UK cases using the same words as were used in the preceding provisions. The words of Articles 12 and 13 are exactly, or pretty much exactly, aren't they, what they were under the preceding regulation?
Yes, they are. But
it has a different effect now.
It has a different effect because they've been, whereas previously they formed part of Schedule 4 to the 1982 Act with its rather indeterminate status, where the court is required to have regard to the decisions of the Court of Justice, but is not strictly bound. Now that the relevant provisions of the maintenance regulation have been imported without that degree of modification, then they have a different effect. If I can go back to Lord Sales's point, I had in mind that as I said, that the Brussels Convention had some ghostly residual purpose. I'm reminded by Ms. Campbell that it still has effect in relation to matters concerning dependent territories or certain other sort of overseas territories.
What do you mean by dependent territories?
I think
you might get some instructions and let us know later on.
I'll try and do that, my lady. But, my lady, if I may say, it is a curiosity that it appears, but if it appears, then we should all assume that it does have some meaning. I'm sorry that I'm not able to be more precise about its continuing existence, but it does appear that it has some, or else it wouldn't be there. So if I can continue dealing with my submissions on unrelated actions, and if I can turn to paragraph 19 of the intervener's written case at 2189, then 4 or 5 lines down, the intervener sets out the principal argument in favour of the maintenance regulation operating as a complete set of jurisdictional rules relates to the promotion of legal certainty, predictability, and the uniform application of the rules. And there are then a number of paragraphs which follow dealing with that point, and I would adopt those arguments, and I wouldn't seek to elaborate on them. But there is also one sentence near the beginning of paragraph 19 where it is said that the arguments against the continued existence of an FNC power, emphasis would be placed on the recognition in the jurisprudence of providing maintenance creditors with a choice of court. So I would say to that, well, yes, indeed. And of course, that leads us back to R&P and the other Court of Justice cases which I've already dealt with. And so I would say, well, of course, taking Lord Wilson's point that the previous regime did allow FNC, that nevertheless, as matters now stand, FNC is excluded. So if I can then move on to, unless there are any other points I can assist with, I'll move on to the 4th issue, which is related actions. And at a fairly early stage yesterday in Mr. Horton's submissions, Lord Wilson said that we would at some point need to put Article 13 under the microscope. I would suggest we haven't actually yet done that. So I would ask the court to go to the, fairly quickly, but to go to the Sario case, which is in volume 1 at divider 7. And so that starts at MS 219. And it's the very short, often cited judgment of Lord Savile. And yes, he sets out what was then Article 22 at page 225 at letter G. And we have what is now, for our purposes, Article 13.3 appears just below letter G, that actions are deemed to be related where they are so closely connected that it is expedient to hear and determine them together to avoid the risk of irreconcilable judgments resulting from separate proceedings. And the whole of the rest of the judgment is predicated on the basis that the risk of irreconcilable judgments is the risk which must be guarded against, and that related actions are defined by what, for our purposes, is Article 13.3. So this is a term of EU law with an autonomous definition, and that definition is to be found in 13.3. So the starting point is that unless there is a risk of irreconcilable judgments, Article 13 is not engaged. And that we see that at page 227, internal page 40, at letter C, where Lord Savile said, in the second place, it seems to me that the words of the article itself militate against the suggested limitation. The actions to be related must be, and then he quotes the words. So that is...
Yeah, let's read on, perhaps, Mr. Scott.
Yes, certainly. To my mind, these wide words are designed to cover a range of circumstances, from cases where the matters before the courts are virtually identical, to cases where, although that is not the position, the connection is close enough to make it expedient for them to be heard and determined together to avoid the risk in question. So, my Lord, it is always there to avoid the risk in question. It is the risk of irreconcilable judgments which alone opens the door to the application of Article 13.
And then, of course, turning over to 228 at F, Lord Savile says, I'm of the view there should be a broad common sense approach to the question whether the actions are related. You can't argue with that.
My Lord, I don't argue with that, but I would, at this point, be the one to read on and emphasize the words bearing in mind the objective of the article.
Yes, fair enough.
Lord Savile goes on to say, it seems to me that this was the approach adopted by Mr. Justice Mance, who concluded that the allegations common to both proceedings in relation to whether the negotiations leading to the sale were conducted by or on behalf of the defendant, as well as the circumstances of the Grupo Torres group in Spain and the defendant's relationship with it, raised a risk of irreconcilable judgments in circumstances where the two actions were so closely related that it was expedient that they should be heard and determined together to avoid that risk. So we always come back to the risk of irreconcilable judgments, without which the article has no application. And that, I would suggest, follows, that is simply a matter of the autonomous definition, which is given in what is, for our purposes, Article 13.3. That is what related actions means.
Where do we find the provisions for enforcement of maintenance and other financial decisions made in England, enforcement in Scotland, or made in Scotland, enforcement of England? Where do we find those?
Lady, may I turn to our Scottish expert that question?
Well, it applies both to England and Scotland. It doesn't seem to me that a Scottish expert is any better equipped to do it than you are.
Well, my lady, obviously one looks outside Schedule 6 because
One
that...
does look outside Schedule 6. That's why I'm asking you where to look.
My lady, I should be able to give a straight answer to that, but I'm afraid I can't.
Well, it's obviously germane to this question of risk of irreconcilable decisions.
Can I give it a bit of colour? Because suppose that a Section 27 order is made here in
Yes.
England, and suppose that it can continue beyond the decree. That was up in question before the Court of Appeal, but isn't being argued at the moment. So suppose it can.
With respect to, in fact, it wasn't. It was accepted
All right,
that it could continue.
Suppose it can. That means that the Scottish Court will determine its question of financial relief in the face of a continuing order for
Yes.
maintenance from the English court.
Yes.
And the English court's approach and the Scottish court's approach to maintenance would be likely to be different if you've got an open-ended order in this country. So that's why I certainly would like to know what's the position about the Scottish court enforcing the English order.
Well, if I can take that in stages, my understanding is that the Scottish court would be unlikely to entertain an application for what we would call in England financial remedies in circumstances where the English court had already dealt with it.
No, that's not the point. The point is
Well-
the Scottish court enforcing the English order, which you want. Where do we find the provisions about that?
Well, that would be a matter of Scottish law. I should, of course, know the converse, which is where we would find the provisions for the enforcement of a Scottish order
Yes.
in England, which I'm afraid I don't. But it may be that I can get instructions on the enforcement of the English order in Scotland.
Yes, well, obviously it's a matter of of very grave concern to you and your client.
Well, my lady, I don't have any doubt that there would be the possibility for enforcement.
It would be good to know where we find those.
Well, may I have a
Be
moment?
amended. The amendment of that order might be material as well.
Yes, variation.
Yeah. Because if it was coming from outside the EU, I mean, within another part of the EU into this country, there would be don't question the substance of the order type of provisions, no doubt.
Yes.
And you'd have to enforce the order made by the other member state court. So I would like to know what's the position within the UK in that sort of way. You'd have to go back, I think, in a external to the UK situation, to the court that made the order to get the variation. If that's, I mean, that's just to give an example. I don't need to have the chapter and verse with regard to that, but it's to illustrate the problem, the practical problem. Where does it get varied? How does it get enforced? And where the assets are in Scotland and the divorce has been in Scotland, what does that bring to the equation?
My lady, so far as variation is concerned, my understanding is that an application to vary is treated for the purposes of the maintenance regulation as a fresh application. And accordingly, for that purpose, the jurisdictional rules of the maintenance regulation, which are imported by Schedule 6, would apply.
We need chapter and verse about enforcement and variation, where we find it.
Well, my lady,
If you would like to provide us with it in writing at a later stage, preferably by agreement with the other parties, that would be helpful.
well, my lady,
Rather do that than do a paper chase during this hearing.
my lady, I think that may be the best course.
One reason for my concern about it is that I am very well aware of how difficult it was to negotiate a treaty between England and Wales and Scotland for the recognition and enforcement of orders relating to children,
Yes, my lady.
because I had some small part in that.
Yes, my lady.
So I just would like to know how things worked out in relation to finances.
Well, I think the answer comes under the Maintenance Orders Act, but we will set it out in writing.
Yes, I would expect it to come under the Maintenance Orders Act, but it would be good to know.
Yes, certainly, my lady. So, my lady, may I then come on to more and more?
Are we leaving Article 13,
No.
the wording of it?
Well, I was going to, in a sense, come back to it via more, but if there are any issues that I can help with, then of course I'm happy to help now.
At some stage, I would be very grateful for help on Article 13.2. If we can just go to the maintenance regulation itself,
Yes.
which is tab 5 in bundle 1 at 109 to 110.
Yes.
First of all, paragraph 3. You've homed in on this, understandably. Deemed to be related where they are so closely connected that it's expedient to hear and determine them together. Actions are deemed to be related, so closely connected, expedient to hear and determine them together. Now that's odd, Mr. Scott, isn't it? How can you hear and determine the actions together? You're thinking of staying one of them. Anyway, they're in different states. Does them really mean hear and determine the issues raised in them together, rather than the actions together?
Well, my lord, I certainly see that the difficulty of applying it literally by saying determine them together, yes.
Can we, for the moment, proceed on the basis that it must mean hear and determine the issues raised in them together?
Very well, my lord, yes.
Now back to number 2. Where these actions are pending at first instance, any court other than the court first seized may also, on the application of one of the parties, decline jurisdiction if the court first seized has jurisdiction over the actions in question and its law permits the consolidation thereof. Now we've noticed, I think in the Owens Bank case, the Advocate General saying, it's actually at 1893, but we needn't turn it up, the Advocate General saying it's not wholly easy to comprehend what paragraph 2 is all about.
Yes.
Perhaps you would associate yourself with that. You would also know that the first words in where these actions are pending at first instance have, in article, the recast B2R, been changed. We find that at 532, but we needn't. Look it up. Instead of where these actions are pending at first instance, for the purposes of the recast regulation, I don't mean B2R, do I? I mean recast number 1.
Yes.
Forgive me.
Yes.
Recast number 1, recast judgments regulation. It now reads for that purpose, not where these actions are pending at first instance, but where the action in the court first seized is pending at first instance. So that might help us a little bit, Mr. Scott,
Yes.
in understanding this. Where the action in the court first seized is pending at first instance, any court other than that may also, so this is an extra justification for stay beyond paragraph 1, am I right about that?
Yes.
Decline jurisdiction if the court first seized has jurisdiction over the actions in question and its law permits the consolidation thereof. Now, can I put to you for your comment, Mr. Scott, this means, as applied to our case, that where the Scottish action, which was first in time, is pending at first instance, which it is, any court other than the court first seized, which means England and Wales, may also, on the application of one of the parties, decline jurisdiction if the court first seized, Scotland, has jurisdiction over the actions in question. Yes, it does have jurisdiction over finance, and its law permits the consolidation thereof. Yes, indeed, not just consolidation. The financial claims would be heard within the writ of divorce. And so my request to you is to explain how our case does not fit entirely within paragraph 2.
Well, my lord, this must come to the question of meaning of when the actions are pending at first instance, because, or as your lordship has pointed out, that might have to be read as the action in the court first seized, and what is meant by the action. Now, at the moment, the only action in Scotland is an action for divorce, for dissolution of marriage. So there is no action in relation to maintenance which is pending in Scotland.
Does the court first seized, namely Scotland, have jurisdiction over finance?
Yes.
Would its law permit consolidation of divorce and finance?
Yes, as I understand it.
You want to say anything more?
Well, my lord, we still come back that if the action which is pending is not, as presently constituted, an action which encompasses financial claims, then the rest falls away.
I wonder whether it can mean that, or whether it means you've got this action. Could this action actually be extended to cover the subject matter of that action?
Well, my lord, if one thinks of this not as between England and Scotland, but this is an EU regulation, so one thinks of it as between all member states, then whether there is jurisprudence to say that any or all of these terms are terms which must be autonomously defined, but that would be the natural inclination of the Court of Justice. What your lordship, the way in which your lordship's argument would follow on, as I understand it, would be to say that the court second seized would have to consider whether, let's say the Bulgarian court would have to consider whether the action in Malta could cover an issue which might be related. And that is surely taking it much too far. It makes it relatively easy if one focuses on England and Scotland, but taking it at EU level, it would presuppose a compendious knowledge by the courts of each member state of the internal laws of every other member state. And I would therefore suggest that your lordship's construction really can't be right.
Is it my construction, or is it the construction of Mr. Justice Moore?
My lord, I don't think Mr. Justice Moore did not make any reference, as far as I can recall in NNN, either to Article 13.2 or to Article 13.3.
He decided it under Article 13.2.
Well, we can go to have a look, my lord.
Let's. Volume 3, tab 41. MS page 1153.
Yes.
Let's go to paragraph 30 first at 1158. Paragraph 29. Second question I must answer is whether or not to stay the proceedings under 13.1 or decline jurisdiction under Article 13.2. I decided I should decline jurisdiction under Article 13.2. So that's something I might have been right about, Mr. Scott.
My lord, you certainly were.
Very well. Thank you.
Lord, I'll come back to NNN if I may, but please go to Moore and Moore, since that has been the subject of some criticism.
I don't think any criticism of Moore and Moore. I think the criticism alleged is of the Court of Appeal in concluding that Moore and Moore was in some way conclusive of this issue.
Well, I think there was criticism of Moore and Moore because it was suggested that there was an insufficient distinction between Article 27 and Article 28.
Right.
So the first point I would make is that in our written case, we've referred to the judgment as being that of Lord Justice Thorpe. In fact, it goes beyond that, because if we look at paragraph 1, and I'm sorry, I should have said, this is volume 1, divided 9, page 254.
Sorry,
254, my lady.
Thank you. Slight problem of noises off, which nobody's fault.
And Lord Justice Thorpe delivers the judgment, but he spells out that the principal architect of the judgment has been Lord Justice Lawrence Collins, who also drafted the section of the judgment dealing with the EC Council regulations. And insofar as it was suggested that the court in Moore and Moore failed sufficiently to distinguish between Articles 27 and 28, I would suggest that it's quite difficult to suggest that Lord Collins, as he now is, would not have had and did not have the distinction between the two articles in mind. But the reason why he treats them together is, as we see if we go on, the judgment sets out the husband's case and then the wife's case. There is then, at page 268, paragraph 76, a section which I'm not going to read out, but a long section on the meaning of maintenance. And the judgment then goes on to deal with the extraordinarily convoluted Spanish procedures, which I'm certainly not going to go into. We looked at them yesterday. But what the judgment goes on to say at 94, that the essential object of the application by the husband was to achieve sharing of the property on his terms rather than an order based on financial needs. And then 95, the paragraph which has been criticised, we are satisfied that the 24th April 06 application was not a matter relating to maintenance for the purposes of Article 5.2, and therefore there would be no basis for the applications of Articles 27 or 20 or 28 of Brussels 1, even if those proceedings were still pending. And it was right at that point to treat them together, because what the court had concluded was that the subject matter of the Spanish proceedings was outside the scope of the Brussels 1 regulation. And learned friend Mr. Horton spoke about whether the cause of action was the same. Cause of action is the language of Article 12, but if the subject matter is outside the scope of what is now the maintenance regulation, then Articles 27 and 28 are equally excluded. And so it was quite right to deal with them in the same breath.
Well, they're just not reached, are they? You say excluded. They're not reached.
They're not reached, exactly. Yes, exactly so.
Was there any independent address of Article 28 in this judgment?
Not directly, but by very clear inference, by the emphasis on Van den Boogaard and on the subject, on reaching a detailed conclusion that the subject matter of the Spanish proceedings did not include maintenance in its scope, then that, in my submission, meant that it was not necessary to give a detailed further consideration of Article 28, because it spoke for itself. Article 28 was equally inapplicable. And so, my Lord, I say for that reason that the Court of Appeal was right here to treat Moore and Moore as a conclusive answer. because the situation in the present case is a fortiori, in that in Moore there were proceedings which had to be analysed closely before the court concluded that they did not encompass maintenance. Here in the Scottish proceedings, there is no mention of finance in the Scottish papers. And so it cannot be said that there is any risk of irreconcilable judgments. Now, my Lord, that is the point which up to now I've had to meet. Your Lordship has raised a separate point in relation to Article 13.2. But, Lord, in relation, and of course I accept that your Lordship is right, Mr. Justice Moore said that he was deciding NNN under Article 13.2. But nevertheless, the criticisms of his judgment, which were made by the Court of Appeal in this case, do stand, because he was proceeding as though the basis of his application of Article 13 was forum convenience. And in the case of an intra-EU case, as distinct from the intra-UK case which we've been debating, but in an intra-EU case, that cannot possibly be right. So I would reaffirm in our submission that the Court of Appeal was correct to find that NNN was wrongly decided, and was correct to find that more and more is a complete answer to the Article 13, the related actions point in the present case. And in any event, in the judgment of the Court of Appeal in the present case, they very clearly did distinguish between Article 12 and Article 13 and applied Article 13. And, my Lord, I would have also to point out that the point which your Lordship raises about Article 13.2 has not formed part of the way in which the appeal has been presented. And without, if I can say it, if it had been presented in that way, then obviously I would have sought to meet it and would have done research on Article 13.2. But since that hasn't been mentioned, except to the extent that it's mentioned in the judgment of Mr. Justice Moore in NNN, that is not a topic which I have come ready to meet. I'm sure that I would have to go back to Dicey and Briggs and the other relevant books and look to see how this has been considered, look to see why the terminology has been changed in the recasting of the Brussels I regulation. I would imagine that there must be jurisprudence on this point. But it is not self-evident that it has the meaning which your Lordship suggests, because one still has to consider what the opening words of where actions are pending actually mean.
Can you help me? What's the provision, I suppose, now in the Brussels recast regulation, which deals with jurisdiction in relation to matters of marital status?
I don't believe it does.
Oh, it doesn't.
No, it doesn't.
It's just
No.
right. So it's just.
I don't think that family law issues have any place in the recast Brussels I regulation.
Okay. Thank you.
Is Brussels II revised?
Yes, there is the Brussels II revised regulation.
Right.
Which does deal with marital status
Can
and
just
parental responsibility.
Forgive my ignorance, but can you give me the reference to that one?
Well, it's Regulation 2201 of 2003. I don't think that, I'm not sure if we have that in the bundles or not. I don't think we do. But if there's any specific question, My Lord, it is a regulation I'm quite familiar with. I would hope I might be able to answer a question.
I just wanted to know where the jurisdictional provision was for, in terms of EU law, to deal with matters of status.
Yes, well, the answer is that it is in the regulation which family lawyers know as Brussels II revised, which I've given the number.
I'm impressed that you knew it off by heart, Mr. Scott.
It is,
Very impressed.
It is my daily meat and drink.
Thank
And
you
it's
very much.
Chapter 2, Article 3, isn't it?
Thank you, my lady, yes.
Thank you very much.
So, 2 minutes of my allotted hour left. If there are any other... may I have a moment? Then, Ms. Campbell has been researching the question which Lady Hale raised about enforcement. We will be ready to deal with it in a written note, I would hope as early as this afternoon.
And preferably agreed with...
And of course we will liaise with Mr. Horton and Mr. Lang.
Thank you.
And so, but I can now say in answer to Lord Sales's question about the residual existence of the Brussels Convention, and my lady asked what are the overseas territories concerned.
No, I didn't. You said dependent territory.
Dependent,
There's no
well,
such thing. So that's why I was...
Well, I should have said overseas territories.
Right.
It is Aruba and the French overseas territories. So it is a very limited scope, but it is still there. And I'm sorry I used the wrong terminology. Unless I can help further, then I will sit down.
Thank you very much indeed, Mr. Scott. Ms. Campbell, do you wish to say anything?
There's nothing more, my ladies and lords, I can say that Mrs. Scott hasn't said already, so thank you.
Thank you. Sir James.
My ladies, my lords, the principal reason, as you know, that the Secretary of State has sought permission to intervene in these proceedings is to address you in relation to Section 2.2 of the ECA, which is obviously a matter of some broader governmental concern.
But you're rather hoping we don't get there.
You may detect from my case that there's quite a strong hope you don't get there. But there are a variety of complicated and different routes by which you might not do that. And rather unusually, at least for me, we've sought, I hope helpfully, to try to take a rather more neutral position in relation to some of the prior issues and set out the arguments which the court may wish to at least address some thought to, rather than taking a strong or firm position. But I wanted to start, if I may, just by making some very brief submissions before I get to 2.2 about at least two of those prior issues. The first one is whether or not there is a residual discretion to stay an application on grounds of forum non-convenience. And the summary of our position is that it is perhaps much more difficult to find that residual discretion in the context of related actions. That there are arguments both ways as to the position under the maintenance regulation in the context of unrelated actions. And there is an overarching point, which is that the basic legislative intent of Schedule 6 was to mirror the jurisdictional provisions, by which I mean both basic jurisdictional provisions and exercise, in the maintenance regulation. So turning first to the related actions position, Schedule 6 of the 2011 regulations, as you know, includes at paragraph 13, Article 13, which is about the exercise of jurisdiction, if that matters. It does so expressly, and it does so with the plain, and it might be thought express intent, that Article 13, as thereby incorporated, shall mean what it means in the maintenance regulation. See Schedule 6, paragraph 1, and Schedule 6, paragraph 3. So the question is whether under the maintenance regulation, and if this were, say, a member state conflict, forum non-conveniens in its English law conception could operate if the actions are related. The basic intention is plain in that context, we submit. Article 13 applies, and to the extent that it deals with convenience issues, which to a large extent it does, both in the definition of related actions, which draw you into a consideration of convenience matters, and in relation to the exercise of discretion, its provisions apply. And it's difficult, we respectfully submit, to see any room for the operation of English FNC in that context. It wouldn't apply in the context of the maintenance regulation, and the plain intention, at least when Article 13 applies, is that that position is mirrored in intra-UK cases. So I suppose the question then arises, which I know is a question that the Court has raised earlier on in this hearing, whether FNC can apply alongside Articles 12 and 13, both of which are incorporated, if I can use that term, in the way I've described. For example, could the court first seized apply it, or could it be done in advance of proceedings being issued in another jurisdiction? As the appellant has fairly acknowledged, we respectfully submit correctly in response to a question that I think my lady, Lady Black, asked, they are strange bedfellows. And that is because at the level of principle, at the very least, Articles 12 and 13 take a very sizable chunk out of FNC for precisely the reason I've just given, namely that Article 13, at least, is shot through with convenience considerations, both in relation to whether the actions are related and in relation to the principles governing the exercise of that discretion if you get to that stage. And that bifurcation, that difference, and that those features of Article 13 were considered, I'm not going to take you to it now, but they were considered in the Alexandros T case at paragraphs 74 and 92 by Lord Clark. The reference is Bundle 6, tab 74, and the relevant page numbers for those two paragraphs are 1843 for para 74 and 1848 for para 92. What about the position if the court first seized is trying to operate FNC in a context?
Sorry, what did he say in a nutshell?
I think he was just describing how the basic provisions of Article 13, or as it then was, Article 27, he was actually considering worked. So it's just a guidance as to what matters you take into consideration. So in 92, when you get to the exercise of the discretion, he draws on the Advocate General's opinion and effectively says it's taking all the circumstances into account, and 3 or 4 particular features are highlighted for consideration when you're exercising the discretion. 1848 is the relevant para. And it's just to make the point that there are plain overlaps between what you would consider if you were doing English FNC and what you would consider if you were doing Article 13 analysis as explained in Alexandros T. If one considers the position of the court first seized trying to apply FNC, the difficulty here is that if the court first seized were trying to do FNC, there is a real risk that they wouldn't be faithfully mirroring the way that Article 13 would work under the maintenance regulation. It isn't just a case of there being parallel, non-overlapping operation of FNC and the Article 12-13 regime. There's the risk of different outcomes, because the court first seized could be declining jurisdiction established under Article 3 for the sake of argument of the maintenance regulation, which Article 13 doesn't permit. Or, I think this was the example that my Lady Black gave, the court first seized declines jurisdiction, and then the court second seized must decline jurisdiction under Article 12.2 if you're in that territory, if you're in same cause of action, same parties territory.
I mean, I wonder whether it's a little bit more profound than that, because Article 3 of the maintenance regulation, MS page 108, specifies that jurisdiction shall lie with particular courts.
And you see that, I respectfully agree, and you see that reflected in some of the case law that you've been taken to, how strong that provision is. I mean, there was a question, I suppose, historically, there might have been a question, that's what they meant by the non-hierarchicized, or whatever the ghastly phrase was. But under the old regulation, under Brussels I, as I understand it, the structure of what is now Article 3 in the maintenance regulation was rather different, because it did say, here's the default rule, domicile or whatever it was, and you can only depart from that if not. But here you've got alternative bases of jurisdiction specified in Article 3, and we know from R&P, the R&P case, that what that has been taken by the CJU to mean is precisely what my lord has just put to me, which is that that is effectively a choice for the maintenance creditor, and if you're in jurisdiction, the jurisdiction shall be exercised.
Well, there is a difference between jurisdiction shall lie and jurisdiction shall be exercised.
That
they
is
are
true.
Two different things. But
That is true. But
it could be that one leads to the other.
It could, and one can see how the difference of structure might have led to debates, but it looks as though the CJU, particularly in R&P and those cases, is taking that as a pretty clear indication that if you're within the jurisdiction, it's a choice for the maintenance creditor and jurisdiction shall be exercised. Operating them alongside each other or trying to would also involve, we respectfully submit, ignoring quite a lot of the CJU jurisprudence in which the CJU has been at least raising considerable concerns about forum non conveniens, precisely because it reduces uniformity and legal certainty. You see that very clearly reflected in that chunk of the judgment in Owusu, where they deal with that issue specifically, and there is concern on that front, perhaps understandably, not least because no doubt some member states do not have that sort of concept, so you'd end up with the possibility of disparity of approach. So we respectfully submit that in relation to related actions, there are real difficulties of principle and application with a parallel operation of English FNC in a context in which Article 13 applies. Just to take that a little bit further forward in relation to related actions, there's still the vexed question of how the legislative position works in English law under the relevant statutory regime, Section 16, Section 49 et al. And I'm not going to travel back over all of the submissions my own friend Mr. Scott has made on that yesterday and today. But it might be thought that if one is standing back from this and seeing how those provisions are at least designed to work or appear to be designed to work at a basic level, a number of things can be said about those provisions. And the key one, perhaps, is that maintenance has been removed from Schedule 4 of the 1982 Act. That is the ... in paragraph 3b that you saw at page 45 in the MS numbering. That was effected, that removal, by Regulation 6 and paragraph 11 of Schedule 4 to the 2011 regulations, which did that removal in terms. And what then happens is that the 2011 regulations then set up a bespoke scheme, a comprehensive scheme, essentially mirroring the maintenance regulation. And so thereafter, once that change has been effected, the scheme does not depend either for its basic jurisdictional provisions or for resolving conflicts if there are two courts which have jurisdiction. It doesn't then depend on Schedule 4 to the 1982 Act at all anymore. It made new and comprehensive provision for the allocation of jurisdiction within the UK in maintenance cases, and it included Articles 12 and 13 for that purpose. So it might be thought, I mean, there may be other explanations, and I confess I haven't chased it through entirely. In particular, my Lady Black might wish to think about how Section 16(1)A works and whether that might provide some route to explaining why subject to is used in 16(4). I suspect that there may be bits in the regulation that still survive, so that may provide some explanation for it. But at a basic level, the subject to Schedule 6 in the 2011 regulations merely indicates the facts that I've indicated already, that Schedule 6 of the 2011 regs now governs the turf that it covers, in other words, maintenance cases. And it's maybe making assurance doubly sure, but that may perhaps not be a vice and may be a virtue. So far as Section 49 is concerned, which I know the Court was particularly interested in, of course it starts with the words, nothing in this Act shall prevent a stay, which I know my Lord Wilson focused on, fine, but consideration of tiebreakers and the resolution of conflicts of jurisdiction intra-UK now takes place, as we've seen, not under this Act, because Schedule 4 has dropped away as far as it's concerned, but under the new bespoke and comprehensive regime provided for in Schedule 6 of the 2011 regulations. So we respectfully submit that there is force in focusing on those first words, but there is also force, we respectfully submit, and I know it's a point that occurred to my lady the President, because she asked the question about it, in asking the basic question, what is the purpose of Section 49? And the answer to what is the basic purpose of Section 49 is really to be found in the second half of Section 49, because what it was trying to do was to make sure that there wasn't inconsistency. And there wasn't inconsistency with provisions in what were, and I think probably remain, only internationally binding instruments and treaties. So the provision was necessary because the 1968 Convention, the Lugano Convention, did not have direct effect. So the purpose and effect of Section 49 was to exclude FNC, if you will, in the context of cases where its application would be inconsistent with the application of those internationally binding instruments. So they have no direct effect, no force in UK law. So you needed 49 for that purpose.
But Section 49 doesn't bring in forum non-conveniens.
No.
It says it's there, and it remains there unless it's excluded by A, B, or C. When we come to look at the new regime, should we not adopt an analogous approach? Forum non-conveniens is there. Has it been excluded by Schedule 6?
My Lord, I think I can probably go with that, if I'm allowed to put it in that rather informal way, because the question, I agree, when you come to the 2011 regulations, is whether or not looking at the scheme as a whole, that's the scheme of the 2011 regulations as a whole, they can and do, or could and might continue to operate FNC as a pre-existing concept, not dependent for its existence on Section 49, having regard to what Schedule 6 did, including in the context of related actions, which is why I focused on that, the direct interposition and the direct incorporation of Articles 12 and 13. It's a point I'll come back to, but we've checked and double-checked, and we don't believe that that Articles 27 and 28, which was the precursor, as you'll recall, of 12 and 13, were ever included in Schedule 4 of the 1982 Act. So at the time when Section 49 is passed, it is passed into a legislative scheme which doesn't include the analogue. Now you may say, well, why has that been done? And I'll come back to that. But it may at least be important to note that 27 and 28 didn't make their way into Schedule 4, but 12 and 13 have deliberately made their way into Schedule 6 in the context of maintenance. Anyway, that's the position in relation to related actions. In relation to unrelated actions, the maintenance regulation, as you know, only contains specific provisions.
Oh, can I just pick you up on
My Lord,
not pick you
sure.
up on it?
If I've made an error,
ask you to help us further on it, Sir James.
Okay.
Section 16.4, if you've got it at 28.
Yeah.
It's tab 3 of bundle 1. Section 16, this is what brings the judgments regulation into the intra-UK territory. Section 16.4, the provisions of this section and Schedule 4 shall have effect subject to the regulation, subject to the judgments regulation. I had wondered whether that means you bring in Articles 28 and 29 into your analysis of Section 16 and Schedule 4.
Well, I'll double check on that. I'm not sure, but I think some of them were brought in specifically, some of the provisions.
Now, I'm not saying specifically.
No, you're saying compendiously.
Compendiously.
But the question is whether that will tally with the introduction of some but not others in Schedule 4 if we get there. But I'll have to check that.
Okay.
I see the force of my Lord's point. I just don't, I'm afraid, know the answer to that without going back to check it.
Okay.
So back to unrelated actions, if I may. I've dealt with related actions. Unrelated actions, we know that the maintenance reg only contains specific provisions that regulate circumstances in which multiple courts are seized of related actions, and there are no specific provisions in the maintenance regulation that regulate circumstances where multiple courts are seized of unrelated actions. So there is therefore no express answer to the question whether the court that is seized of the maintenance claim in this case, if it is unrelated, and I make no submissions either way about that, has a discretion to stay on FNC grounds or not. There simply isn't an express coverage of that in the maintenance regulation. And it was for that reason that we set out in our written case, and I'll just touch on them very briefly because it's really no more than a summary of what's already there, effectively 3 arguments against the existence of a power to stay in the maintenance regulation in relation to unrelated actions, and 3 arguments in favour of the existence of the power to stay. And those arguments have been referred to by my learned friend Mr. Scott this morning. The arguments against the continued existence of an FNC power in the maintenance regulations are principally, first, that the maintenance regulations were intended to provide a comprehensive code. They provide a complete set of just jurisdictional rules relating to the promotion of legal certainty, predictability and uniformity of application. Secondly, it might be thought that Owusu supports the proposition that allowing forum non-conveniens in the context of the maintenance regulation at all is likely to have an adverse effect on that uniform application. See paras 41 and 43, 41 to 43, especially in that regard, Authorities 5, tab 56, pages 1612 to 3. And thirdly, that the purpose of the maintenance regulations was to provide maintenance creditors with a choice of court on the basis of specific jurisdiction and tightly circumscribed seizing provisions. The 3 arguments in favour of the existence of a power to stay in the maintenance regulation: 1, there's nothing in the MR prohibiting the exercise of FNC in the context of unrelated actions. The mandatory A12 and A13 rules do not apply, and there's simply no regulation of the position in relation to unrelated actions. Secondly, the existence of jurisdiction does not require the courts of a member state validly seized to exercise jurisdiction. And we can see from Article 3 there are a range of situations in which, or courts from which the maintenance creditor could effectively choose. And thirdly, and I think this would need to be focused on, the judgment in Owusu is not precisely on point, would have to be the argument. That case was concerned with a situation where there are or were related actions and so on. But we've set those out in the written case, and I don't develop them here. I just know that there may be arguments both ways, but it's much more complicated where you're dealing with unrelated actions for the very simple reason that there's no express provision. And then one comes, in relation to unrelated actions, to the 2011 regs, and in those circumstances, I submit simply that the basic intention of the 2011 regs, and there may be fiddly bits around the edges of it, but the basic intention was to import the maintenance regulations into intra-UK cases. And if that's the basic intention, the position under the domestic regime is very likely, at least, to mirror that at the EU level. So you get the same answer under the 2011 regs, is the argument. Either way on that. So that's what all I wanted to say by way of introduction in relation to the residual discretion issue. The second area, just to focus very briefly on, is whether or not the maintenance regulations have direct effect in relation to intra-UK cases. And I've raised that for consideration for the obvious reason that if, whether it finds favour or it doesn't, I'm not advocating a particular answer to that, but if they do have direct effect, then obviously the 2-2 issue does not arise, because the effect of removal of FNC, if that's what's happened, is created directly by the MR having direct effect. And I do respectfully submit that it isn't an entirely straightforward issue, whether they do or they don't, or whether some parts of the MR do or they don't have direct effect. It involves, in effect, trying to predict where the CJU might go in relation to the reach of those provisions, and the strong tendencies you see from all the recent case law is to favour uniformity and the broad application and reach of the regulation. So the boundaries are forever being pushed outwards, as it were. Lots of arguments run by the United Kingdom government, for example, that says it's only about MR cases, MS cases, member state cases, have been rejected on a couple of occasions, as you saw from our case.
Would Schedule 6 be completely redundant if the maintenance regulation had direct effect?
Well, if some of it did, it might do. It might do. I fully accept that. If it applies to intra-UK cases, then you wouldn't need it.
No, quite.
But the question of whether it does or it doesn't have direct effect, or whether some of its provisions do or don't apply, can't be answered by whether a member state chooses to pass its own law, in effect replicating it. So I submit that that direct effect question is truly a question of working out how the European Court in Luxembourg would approach that issue. That's why we raise it. But I fully accept that if it does, in all respects, then you didn't need Schedule 6. I also ought to acknowledge, particularly when you go back to some of the cases I'm going to invite you to reread when I give you the paragraph numbers for this purpose, that it is at least conceivable that the European Court might reach a different answer in relation to some provisions as compared to others, and in particular might reach a different answer in relation to what I call the basic jurisdictional provisions, Article 3, for example, as compared to Articles 12 and 13, because you see distinctions being drawn in some of the jurisprudence coming out of Luxembourg on the flip side of this argument, between, on the one hand, the base jurisdictional provisions, and on the other hand, the exercise of jurisdiction provisions, as my Lord has identified. Again, I'm not going to spend long on it, because I want to get to 2.2, but the basic provisions and the basic arguments are set out in our case, and perhaps the only point really to note, orally, is that we respectfully disagree that it is either accurate or not overly simplistic, simply to assert, as the appellant does, that the CJU is entirely unconcerned about the allocation of jurisdiction internally. I can see there are arguments both ways, and I'll sketch very briefly, if I may, them, but we do respectfully submit that it isn't as straightforward as just simply saying that. And that is, apart from anything else, because there are cases in the CJU which treat the jurisdictional provisions, by which I mean the base jurisdictional provisions, as in effect establishing a right for a claimant to bring proceedings in a court which has jurisdiction. It flows, for example, from the references, and of course I accept the point my Lord Wilson put to my learned friend this morning about that focusing on a place, so you need to be careful about over-expanding the reasoning, but the thrust of the case law seems, if not set, at least tolerably flowing towards an end point where maintenance creditors and the protection of maintenance creditors is given particular focus. They've treated the Article 3 bases of jurisdiction, CR&P in particular, as in effect establishing the right in the maintenance creditor to choose, and they have applied those basic jurisdictional provisions and that basic maintenance creditor choice in contexts which do involve a purely domestic situation, if I can put it that way. And in doing so, and you saw the emphasis we gave to this in our case in relation to the Sanders case, which I know you're very familiar with, they've drawn distinctions, at least in some of the paragraphs, between, on the one hand, what they call territorial jurisdiction, and on the other hand, what they call international jurisdiction. So we do respectfully on this point invite the court to at least consider whether or not at least those basic jurisdictional provisions might not be held by the CJU to have direct effect, even in a case or a context which was within a member state. We know the way it's expanded outwards through all the various cases involving non-contracting states. We've got a case which involved Jamaica, as you know, that was the Owusu case. We've got a similar case reaching an identical decision later on in UD and XB, but that time in relation to, in that case in the context of Bangladesh. And we've got at least two examples of a purely domestic situation in which they hold, in effect, that the jurisdictional provisions establish a right in the maintenance creditor to go to the court which holds jurisdiction for the purpose of Article 3. See for that purpose the Sanders case. I'm not going to go back to it. The key paragraphs are 29 31, Authorities 5, tab 59, page 1654, and R&P, which is perhaps the clearest of all very recently, Bundle 5, tab 61, especially at paragraphs 30 to 31 and 42, 44 and 45, essentially emphasizing the themes that Chapter 2 of the MR contains underlined and quote all the rules, and it's no longer appropriate to refer to national law. And you'll recall that that reflected a provision in the recital to the maintenance regulation. I think it was recital 15, which referred to that in terms. Secondly, emphasizing the theme and making clear that a court can't simply decline jurisdiction if they have it under Article 3, as they put it in 44, in favour of a court which in its view would be better placed to hear the case, and identifying that the jurisdictional rules are indeed intended, that's the base jurisdictional rules, are indeed intended to give priority to the applicant's choice, as they put it in 45. And so one sees, as it were, a pretty clear drift, at least in relation to the basic jurisdictional provisions, and then the question is whether the exercise of jurisdiction provisions go with that logic or don't. One can see arguments both ways for saying they do or they don't. But that at least is the argument in favour of direct effect. Whether you buy it or not is a different matter. I'm not banging a particular drum for it. And I fully acknowledge on the other side of that debate that in almost all of those cases there is a reference and repeated reference. It might be thought slightly illogically because this is all about choices between different legal jurisdictions as opposed to different nation states, it might be thought, because that's really the stuff of the debate. But there are in all of those cases references and repeated references to international, to cross-border, as being a kind of essential feature to the application of that part of the convention or that part of the regulation at a basic level. And that was effectively the reasoning of the Court of Appeal, the strong Court of Appeal, of course. It had Lord Dyson in the chair, in Cook and Virgin Media, Bundle 1, tab 12, page 339. But I raise it, and the conclusion I invite you to reach is that it isn't such a straightforward issue after all, and that the European Court might well at least be tempted to go for direct effect, at least in relation to the base jurisdictional provisions. And it's against... That
rather sounds, Sir James, as if you're inviting us to make a reference.
Well, my lady, I'm not. We've got lots of... no one, I think, has invited the court to make a reference. And you are the Court of Final Appeal, so you know the rules.
We know the rules, yes.
You know how it works. It'll be a matter for you to judge whether there are arguments there or there aren't. But we thought it right at least to raise them. I'm not sure that makes your job any easier, but they have to be confronted, because if there is a reference, if there is direct effect, we don't get to 2.2 at all, or we might not get to 2.2 at all. That's all. Can I turn to 2.2 in the remaining period?
Can I just ask you before you do, if you are suggesting that there might be room for forum non-conveniens where there are unrelated actions, then in the civil incarnation, externally, if it's civil actions, and not now under the 2011 regulation, but civil actions, externally, Brussels 1 revised does not allow for any space for forum non-conveniens, see a wuzu. So you'd be interpreting it differently. It's a complete code in the civil actions for external cases. Articles 12 and 13 are the reasons why you can say this court is not going to deal with that. So it would be interpreting it differently.
I think you're right. I think it would. You would end up with that inconsistency. Maybe that's an argument that needs to be factored in.
Yes.
Quite met by 27, 28 not being in Schedule 4, if I'm right about that. I'll have to think about it.
It gets quite complicated.
It does get very complicated.
But it would be a difference.
It would be a difference. I think you're right. Unless someone nationally tugs whatever gun I used to have.
If we did make a reference, what would the government's submissions to the CJEU be on direct effect?
I'm not sure I'm allowed to say. I'm not prepared to answer that.
I think you are allowed to say that.
I think I'm better off.
You could say you've no instructions.
I'm better off not answering that until a reference has been made and those sorts of choices are set out very clearly for me. Beyond my beyond my ken, but B, beyond my power, I'm afraid. So I'd better be cautious about that.
Of course.
Section 2.2, if I can turn to that, and I start with the core principles. 2.2 is in Bundle 1, Tab 1 if you want it, but the focus of the analysis under 2.2b, which is the one we're concerned about, is whether the measure is dealing with matters arising out of or related to the EU right or obligation agreed by the UK to be made part of domestic law. That's the question. And we invite the court to conclude. I can take them tolerably quickly, so I don't think there's much of a dispute about the basic principles, and we get to application rather quicker. But if I can take them tolerably quickly, we respectfully submit that there are 5 principles that emerge from the case law, and in particular, and I know you all have read it, so I'm not going to turn it up, I'm going to just give you the references if I may, but if you want Nolan, which reviewed all the earlier authorities, it's in tab 13 of Bundle 1, MS 352 is the first page of it. The first principle that we respectfully submit you get from the case law is that the related to element goes further than the arising out of element. That's clear from the structure of the provision and is confirmed by the analysis of both Lord Mance in Nolan, para 61, at page 385, and Lord Carnworth, para 97, at 396. Secondly, the concept of related to must be read in its particular statutory context, and it is that statutory context which indicates the boundaries of the concept's coverage or scope. The flip side of that is the point made by Lord Carnworth in Nolan at paragraph 94, page 395, that if you took it out of context, the words related to become, as he put it, so wide as to be almost meaningless. And the contextual constraint is provided and bounded by the fact that the primary purpose for which 2.2 exists is to bring into force laws which the UK has agreed to make part of its laws, and it follows that any provision under 2.2b must be for the purpose of implementing or dealing with a matter arising out of or related to that EU obligation or right. It must be a relationship derived in some way, therefore, from EU law. And that's why you have the position where related to will not be satisfied if it's a simple ministerial decision to do things, and on policy terms that relation can be broken. Thirdly, is a thus submission. Thus, in order to respect both the language of the provision and its context and purpose, there must be a relationship which objectively and closely, as the phrase used, exists between the measure in question and the EU scheme, that is, the obligations and rights being implemented. That formulation of naturally arising from or closely relate to was initially adopted by the Court of Appeal in the Oakley decision, at paragraph 39 in particular in the judgment of Lord Justice Waller, Bundle 1, Tab 8, page 245. But Lord Justice May expresses a similar view at 47, where he said that 22B covered the case of provisions, as he put it, which have the effect of tidying things up or making closely related original choices which the directive does not necessarily require. That's the phraseology at 47 of Oakley. And finally, Justice Jacob at paragraph 80, confirming that 22B does indeed, as he put it, add more. And that reasoning of the Court of Appeal in Oakley is then picked up in Nolan, see Lord Mance at paras 56 and 61, 385 and 383, and Lord Carnworth at 89, page 393. Fourthly, a sufficiently objective and close relationship will exist if the measure in question represents an extension beyond pure implementation, almost always will do so by definition, which is designed in the light of the implemented scheme to create a workable and coherent unified scheme of legislation. And see in particular for that purpose Lord Justice May in Oakley, and see for a practical illustration of that the Pothecary case that Mr. Justice Underhill, as he then was in the chair of the EAT, paragraph 42, emphasising the importance of consistency of approach and so on, and the coherence of the legislative regime that would then be created. Finally, and a principle which doesn't necessarily help you answer any particular case, but needs to be put out there anyway, the application of 22B is highly fact and context sensitive. Each measure will need to be considered, applying the statutory related to test as shaped by its legislative context and the jurisprudence of this court. And the majority in Nolan, it might be thought, was at pains to avoid setting hard-edged rules, instead setting down rather core principles which would ensure at least a sensible degree of flexibility, particularly in creating coherently operating legislative regimes. And it might be thought the real interest in Nolan lies not so much in the exposition of those 5 principles, but in what Lord Mance thought about the various mapping, if I can call them that, examples that he then goes on to consider in the judgment, which at least provide you of an indication or a flavour of where he thought the boundary covered by those tolerably broadly expressed principles might lie. And he starts that exercise in Nolan, and again I know you'll be very familiar with it. He starts that mapping exercise at paragraph 63, and he starts by identifying 2 examples at opposite ends of the spectrum. At one end of the spectrum is the position in which there is a directive cast in general terms and leaves a member state free to decide on the precise means for its implementation. That falls squarely within section 2.2. There's a direct relationship there between the EU obligation and the implemented measure.
Could you give us a page reference?
358.
Thank you.
385, I'm so sorry, 385. Para 63. And then at 64, we see another example at the other end of the spectrum where a directive expressly confines itself to a particular field or expressly carves out a particular situation. And that sits at the other end of the spectrum, and he gives the example of risk management partners and Brent at 64 in relation to that. And then we come at 65 to what he described as the intermediate situation, which have to be considered on their own merits, 65 and 66. And he gives there the example of the Apothecary case, which I've already referred to. Remember, that was the one that took victimisation, legislated for victimisation, covered by the lodging, coherence of the scheme and so on. He considers that at 66 and describes the result in that case, that's in the Apothecary case, as unsurprising. See para 66. So in terms of the application of those principles to the present context, if I can move to that, the premises on which we get to this point is that the 2011 regs remove the power to stay on FNC grounds. Just dealing with how we get to 2.2, what are the basic premises when we're here? And that is the basic premise, that the regs remove the power to stay on FNC grounds, and they do so because in intra-EU cases they apply the rules and principles in the maintenance regulation effectively, and the MR does not permit FNC in related actions because Article 13 governs, and in unrelated actions, query, query, for reasons given above, depending on which way you jump on that issue. And we make 4 points on the application of Section 2.2 here. The first is that there are real and difficult issues as to the precise scope and effect, and indeed future direction, of the Luxembourg case law, of the regulation, of the maintenance regulation. Difficult issues as to how that works. Real questions about the extent to which it regulates unrelated actions, real questions about what position would be taken in relation to FNC in the context of unrelated actions, real questions about the extent to which it does or doesn't regulate intra-UK jurisdictional issues already. And the fact that there are issues of that kind and that those questions arise, at the very least, indicates two things. It indicates that the boundary between what has direct effect under 2.1 of the ECA and is thereby implemented under 2.2a and what is implemented under 2.2b may be relatively unclear. But secondly, it indicates that even if we're within 2.2b territory, it's only because we've, if I can put it this way, just fallen over the border into 2.2b from 2.2a, and that demonstrates a degree of closeness. Secondly, it is entirely unsurprising, we respectfully submit, that the appellant has accepted in terms that Schedule 6 is indeed related to the maintenance regulation. The appellant is only challenging the varies of Schedule 6 to the 2011 regulations insofar as it excludes the power to stay maintenance proceedings on the basis of FNC. That is quite properly not a full-blown attack on Schedule 6 or on the alignment of intra-UK and cross-border cases. The appellant is not challenging the fact that Schedule 6 makes provision for the maintenance regulation to operate within the United Kingdom, or the alignment of those intra-UK rules, therefore. Indeed, as the appellant concedes, such alignment was, as it's put in the appellant's case at paragraphs 64b and c, entirely unobjectionable and probably a justifiable policy decision, quote, related to the coming into force of the maintenance regulation. But if that concession is made, that acceptance entirely properly made is made, it is very difficult, we respectfully submit, to see how you can keep the tiger in the cage, to move from the cake analogy. Very difficult to see how you can split out FNC from rules otherwise aligned. You'd have to say that the basic rules were related to, but rules such as A12 and A13 of the maintenance reg incorporated, as we've seen, were not. And that's extremely difficult. Schedule 6 is expressly intended to be a mirror of the maintenance regulation. The only way you get to 2.2 is if the court has held that the maintenance reg does not contain any power to stay on grounds of FNC, and decisions about incorporation of the maintenance regulation rules governing exercise of jurisdiction are plainly related, we submit, to rules about incorporation of the basic jurisdictional rules contained in the maintenance regulation anyway. Indeed, it might be thought that the inclusion of a power to stay on grounds of FNC in Schedule 6 would have undermined the objective and close relationship between Schedule 6 and the maintenance regulation. Thirdly, we do submit that there is a sufficiently objective and close link between the subject matter and the purpose of Schedule 6 and the subject matter and purpose of the maintenance regulation. The subject matter of Schedule 6 is essentially the same as that of the MR. Schedule 6 is merely a mirror of the obligations under the MR. It only applies where the court of a particular part of the UK has jurisdiction, where the subject matter of the proceedings is, quote, within the scope of the maintenance regulation, as defined by Article 1 of that regulation. So Schedule 6 is introduced to coincide with the maintenance regulation becoming directly applicable on the 18th of June 2018. That was the purpose of it. But there's also a symmetry, not merely in relation to subject matter, but also in relation to underlying purpose. The maintenance regulation reflects a policy decision to offer, in effect, alternative bases of jurisdiction to the maintenance creditor. And that was rolled over into the 2011 regulations, including Schedule 6, and we see that at paragraphs 28 to 30 of the Court of Appeal's decision in this case, MS 226.
Thinking about you saying it's a mirror, that it reflects it, what's the explanation for not replicating the provisions as to when a court sees?
Article 9.
Yes.
Well, we've scratched our heads about that, and I don't think there's any terribly clear answer to that. It's not evident from the pre-legislative materials or indeed anything else quite why that was left out there, and we entirely accept that it's not terribly satisfactory it isn't there. But in fairness, I think the best answer that can be given to that is that that absence does not affect the basic mirroring intention, and there are ways in which that sort of issue has had to be solved, but has been solved in the past. But I think that's the best I can do. I don't think we haven't been able to find any coherent or clear or indeed any explanation as to why that provision isn't in there. But we know that seizing is referred to in A12 and A13, so you've got to grapple with that question, and the question is how, but there's not a very easy or clear answer to that, I'm afraid. The fourth point is that the application of the maintenance regulations to intra-UK cases is driven by and is designed in the light of the implemented scheme, that's the directly affected MSMS scheme in the maintenance regulation. It is designed to create a workable, coherent, unified scheme. And that's particularly significant, it might be thought. Others will have far greater experience of these cases than I do, but it's particularly significant, it might be thought, given that maintenance cases increasingly, as I understand it, have connections with a number of jurisdictions and not just neatly, as it were, with simply 2 member states. And that requires clarity of jurisdictional rule and jurisdictional approach in terms of the principal basis on which the jurisdiction is exercised and jurisdictional conflicts are resolved. And a coherent, unified scheme of this kind avoids, for instance, the complexity that would flow from having different rules operating where there are, for the sake of argument, 3 competing jurisdictions or 3 different jurisdictions, England, Scotland and France, and so on. And there is an analogy, therefore, between that legislative aim, intent, and basically benign fundamental purpose and the unsurprising, Lord Mance's word, result in pothecary, which we respectfully submit indicates in Apothecary a perfectly sensible decision to unify the provisions regarding burden of proof for claims relating to discrimination and victimisation. And the courts, and in Nolan it was considered to be a good example of a closely related measure, and we submit the same applies here for essentially the same reasons. I mean, the alternative, one tests it in this way, to the introduction of Schedule 6 in the form it's in, would have been to leave the position unchanged and to apply the previous Brussels I jurisdictional rules to intra-UK cases, for the sake of argument. But one can see immediately the difficulties that might create, where you've got a dissonance, even in relation to the basic jurisdictional provisions, because they were set up differently. I think a member of the court asked what's the extent of the differences, how much was changed. And I think the best answer to that is probably in tab 66 as a sideways table which explains what was implemented and how it was implemented. But without wishing to go into the interstices of all of that, at the basic level of the structure and nature of the core jurisdictional provisions, there is difference between the position as it was, that's a non-hierarchical, and all of that, different structure between paragraph 3 of the maintenance regulation and the earlier provisions under Brussels I. So we do respectfully submit that coherence is an important point. And we add finally, having given you those 4 points for your consideration, we add finally, and for good measure, that this is not, on any view, and I don't think anyone suggests that it is, a case which falls within Lord Mance's other end of the spectrum. We're not in risk management partners territory. There's no provision that excludes the application of the principles in the regulation to intra-UK cases. Indeed, it might be thought that there are a number of provisions of the maintenance regulation which do, on any view, directly apply to intra-UK cases. I'm not going to go back over that debate. I wanted, finally, if I may, to pick up a couple of points that I know the court has indicated some concern about, and to try to address those as best I'm able. The first is whether or not this is a large measure, not a small step, because, so the argument is put against it, it is altering the position under the primary legislation as exemplified or set out in section 49. And we make 3 points in relation to that. The first is that it focuses on the wrong relation. The question, for present purposes, is not a question about proportionality, as it so often is before this court. This is an objective question about varies, which fundamentally collapses into the question whether there is a close enough relationship. What's the relationship between? It is, in essence, whether the exclusion of FNC in the 2011 raise, because that's the premise, for example, by the express application of Article 13, is related to the obligation in the MR. It's that so the relationship you're looking at is between the 2.2b measure and the European obligation or right, which exists here by way of direct effect in the maintenance regulation in Article 13. And the small step referred to in Apothecary refers to that relationship, not to whether or not a member state may be taking a bigger step in terms of its own internal constitution. And we note in that respect that even if that were to be a consideration, i.e. the constitutional position within the member state itself, and a big step relates to that rather than to that relationship between the obligation or the right at the EU level and the implemented 2.2b measure, we would note and invite the court to note that the provision which is relied upon for this purpose, section 49, is in the primary legislation, at least originally, because originally it was dealing with international conventions that had no effect directly in UK law, and you needed primary legislation to make those part of English law. So the vehicle was there, if you will. That's why primary legislation was being used. So it is to some extent accidental or adventitious that this was in primary legislation. I think even at the stage of the 1968 convention, it was the section 2.2b was at that stage a mere twinkle in the eye. The 72 Act didn't come in until some years later, but even when it's used, the primary legislative vehicle appears to be used, and Section 49 exemplifies this, because what it's doing is to, as it were, say, don't act inconsistently with those international instruments, those international conventions, which otherwise would not have any direct UK effect. So that's one point to note. The second point to note is that 2.2 and 2.2b amends primary legislation all the time. That's its basic function. You're trying to align, you're trying to create coherence, but you're doing so by, and in this respect, by allowing subordinate legislation to be made for the purpose of bringing coherence to the domestic legislative regime in the light of a change made in Europe. So it focuses on the wrong relation, is our first answer to that. Secondly, in relation to the maintenance regulation, we do respectfully submit that the maintenance regulation indicates a drive towards greater harmonisation, greater emphasis on legal certainty and all of that, but greater harmonisation. And that is certainly the drift of the case law, the four cases I gave you earlier on, Owusu, RMP, Sanders, and UB and XB, if I've got the acronyms right. And that's strongly reflected in the recitals. I've referred earlier on to the recitals. See recitals 9 and 15. Maintenance creditor has the choice, and the reasoning in RMP post-dates, but conforms entirely the approach evident from the recitals in any event, and no ref to national law. See recitals 9 and 15. And it's unsurprising, therefore, that in relation to that jurisdiction, the basic intention should be to mirror, including adopting what is now Articles 12 and 13 into the intra-UK position, and that the government and Parliament should choose to do that, which was not done before, and bring over those provisions. So I say I think I'm right, partly the point my Lord Wilson raised about 16.4 and whether it's come in anyway. I think I'm right in saying that Section 49 sat as part of a package in which 27 and 28 didn't come over, at least directly, into Schedule 4. That's the second point, therefore. There is good reason for taking a different approach in relation to the maintenance regulation, with all of its new emphasis on uniformity and the applicability of those rules. The third point to make, it touches on the question, isn't FNC an important principle? And there is absolutely no doubt that it is necessary to have a tiebreaker or a set of rules if you have basic jurisdictional rules that may lead to different courts having concomitant jurisdiction. You've got to have a set of rules that enables you as a court to sort out how you deal with those sort of things. But, and it's quite an important but the MR, the maintenance reg, provides for such rules in the context of lis pendens and in the context of related actions, and it's impossible to say that Article 13 is, if you will, an unsatisfactory alternative to FNC. It may be different, but it plainly applies in the context of member state cases, and it's satisfactory there, and they are directly effective rules for the purpose of resolving MS-MS disputes. But the principles are not unsatisfactory inherently, and they are not, we would invite you to note, and that's perhaps the other significance of Lord Clarke in Alexandros T, the passages I gave you earlier, they are not fundamentally dissimilar, because you consider convenience issues with whatever focus on irreconcilable judgments and the risk thereof. You consider it at the point where you're considering whether the actions are indeed related, 13.3, and you consider it at the stage, that's convenience issues, at the stage of exercising that discretion. And in the context of unrelated actions, there are arguments both ways. I'm not going to go back over that. So we respectfully submit that there are good reasons for, as it were, treating, if I'm right about the difference of treatment, for treating the maintenance regulation rather differently, and in particular for dragging in to our intra-UK system the rules in Articles 12 and 13 directly, for all of those reasons. But the fundamental point of principle is focus, if I can invite you to do that, on the right, and what we respectfully submit is the right relationship. And as I say, we're not dealing here with proportionality, we're dealing with the objective question of related to. The second and final area I want to deal with, if you'll indulge me, is was there good consideration of this? And I know my Lord Wilson was particularly concerned about that aspect of it. 5 days, you're right. 5 days, it was made on the 13th, made and laid on the 13th of June 2011, into force on the 18th of June 2011, but
laid on the Monday, in force on the Saturday, 4 clear days.
4 clear days, my Lord, yes. 5 days in total.
Without Parliament being informed that there was an presumed abrogation of FNC, which it have expressly provided for in Section.
Well, I'm going to come to that directly, if I may.
Please.
Just on timing first, if I may, just finish that thought. You're right on the days of the week. We too had checked them, and there is a but. It may not be a great but it's a but nonetheless, so I should give it to you. As the explanatory memorandum notes, the SI was preceded by technical consultation and a period of technical consultation, as you see from the explanatory memo behind, I think, tab 66 in the 6th of the, or 5th of the authorities bundles. And that memo also, if I can just give you the reference to the paragraph numbers, para 3.1 to 3.4, explains why it is that the usual conventional rule of 21 days was shortened. And in a nutshell, and I hope I don't do anyone a disservice, there appears to have been a bust-up within government, and the committees that have to clear.
Well, the maintenance regulation was coming in on the 18th of June.
It was.
And so you had to get these in force then.
We did. There had to be correlation in that way, but that doesn't, if I may respectfully make a point against myself, that doesn't necessarily excuse not doing it 21 days earlier.
Indeed.
To give them the time. But so 3.1 to 3.4 of the explanatory memo explaining why that 21-day rule wasn't met, a conventional rule, I emphasise. Final point perhaps to note on timing is that you'll be aware that under the relevant bits of legislation, and we don't have them here, but I hope you'll take it from me, I think the position is that irrespective of making, Parliament still has 40 days from the laying within which to produce a negative resolution. I think that's under the Statutory Instruments Act 1946. So it's still got that period, and the structure is if it's been made in the meantime, you then, I think, have an order in council which revokes it, is the way it's done. So, and not terribly satisfactory entirely, except for just the reason that my Lord Wilson has given, which is by then, if they were to do that after the 18th of June, you've already got the unsatisfactory disconnect being created. Then to come to the point, my Lord...
Sir James, I have to hurry you up. You're already
yes,
a few minutes after time,
so sorry.
which is very unlike you.
It is. Well, there's been quite a lot to cover. Final point, was the explanatory memo positively inaccurate? We accept that there was not full alignment with Brussels 1, most notably because 27 and 28 weren't carried over, so there isn't that equivalence. But in defence of that document, it is necessarily intended to be a high-level description of the legislative intention behind the 2011 regs, and when you go back to it, you will see that the core and central focus of it was to ask the question whether there should be alignment of the base jurisdictional provisions. That's what they're really considering. That they're looking to see whether you could just stick with Brussels 1 or whether you needed to drag over, in effect, Articles 3 to 8 of the maintenance regulation. That was the central focus. And if they'd gone into FNC and tried to deal with FNC, it might be thought, particularly given my earlier submissions, that that would have been quite a long, detailed and potentially unhelpful explanation. But the one thing that can be said about FNC is that it was absolutely clear on the face of the regulations themselves that Articles 12 and 13 were being brought over and were being introduced directly. Final point, Regulation 10 report Not yet, I'm afraid.
What do you mean? Must. There must be a report by June 2016.
My Lord, that is true, and it is unfortunate that there isn't one. I think the intention, I'm instructed that the intention was to align the carrying out of that review and the reporting at the same time as the European Commission's review referred to in Article 74 of the Maintenance Regulations. I fully accept that the domestic legislative obligation is not conditioned in that way, but that is, if nothing else, at least the mitigation or the explanation as to why that hasn't happened. But the factual position is that there hasn't yet been a Reg 10 report, I'm afraid.
Well, there we are. You have to stand there and say so. Yes.
Sometimes I just have to say to you, it is as it is.
Yeah.
If you recall that. My lady, then on relief, we've dealt with that in the case. You know that there are sensitivities if there is a need to change as to precisely how that should all work.
Yes.
And those are my submissions, and at least in relation to my lady, with sadness and the very best wishes, that's the last time I will say that.
Oh, Sir James, how very kind of you. And the feeling is mutual.
Sorry to have gone over time.
Well, Mr. Horton, you can have your full half hour, should you need it.
Ladies, my lords, can I deal with the question that my lady asked in relation to the power to, or the scheme of recognition and enforcement within the United Kingdom?
Maintenance Orders Act 1950?
Indeed, my lady.
Yep.
Section 16 allows for recognition and enforcement. It's in the Family Court Practice at page 1066. Sections 21 and 22 deal with enforcement. I referred yesterday, my ladies, my lords, to part of the 2011 regulations that amended that Act, and that is at MS 197, because where a court was deciding whether or not to enforce an incoming order, if I can use that expression, it also had the power to remit arrears and to vary the rate of payments, much like the magistrates' courts did for High Court and County Court orders before we had the Family Court. And the amendment, as I understand it on page 197, was to prevent that in the analogous situation to Article 8 of the Maintenance Regulation. Now that was a decision, as it were, to align the primary rules of jurisdiction in the Maintenance Regulation into the intra-UK scheme. We had no obligation to do that. And I don't say that that is ultra vires, the issue doesn't arise in any case in any event. If I can just put that to one side, if I can just then turn on to issue 1 very quickly, and just deal with a point that my learned friend dealt with in relation to orders under Schedule 1 to the Children Act. The point I made already is that the wording of those provisions are very different to the wording of section 27.2. Learned Friend's written case at MS 2153, paragraph 38A. Of course, our primary submission on that issue is that the maintenance regulation is simply not engaged in a purely domestic case, and so the first part of paragraph 14 as set out there doesn't apply. It says if an application is governed by both the EU scheme and the domestic scheme, then it shall not exercise jurisdiction unless, well, of course, it's a purely domestic scheme. We're not forbidden from exercising jurisdiction. One point that I made in our written case was the availability and continued availability of legislation which used to be only available in the Magistrates' Court. If I can take you to MS 2107 and footnote 41, when the Family Court was introduced, the powers that were previously only available in magistrates' court under the Domestic Proceedings and Magistrates' Courts Act 1978 were extended to the family court, and that has unrestricted jurisdictional provisions. And so if we're right that section 27.2 is excluded, that section would still apply. I said that that provision was moribund and redundant. It may well, in fact, not be redundant if section 27.2 bites and there's no jurisdiction internally. It's certainly moribund. I hazard a guess that there are even fewer applications under the DPMCA than there are under section 27. Can I turn next, excuse me, to the direct effect of the maintenance regulation on internal allocation of jurisdiction within the UK. First point to say is that my learned friend's written case at paragraph 42A at excuse me, MS 2155 albeit that is in the context of a different argument, we say that he was absolutely right there and he was right first time and he has no need to hedge his bets in relation to that. And the reason for that, at the risk of repeating myself, is the wording of Articles 12 and 13. On both occasions, they refer to proceedings in more than one member state. So they're not concerned with more than one set of proceedings in the same member state. And whether or not Articles 12 and 13 are of direct effect, of course, we say they are in an international case. Whether or not that's the case, they don't, even if they are directly effective, govern the position here. And so it can't be that forum non-conveniens was removed under section 2.1 or under section 2.2a. And to say otherwise would be to rewrite them and to say wherever there is more than one set of proceedings governed by this regulation, then the court second sees must stay and or decline jurisdiction. And of course it doesn't say that.
But I thought the Sanders and Huber case is CJEU authority that to some extent the maintenance regulation may have direct effect within a state.
My Lord, I
think it was more by reference to Articles 3 than Articles 12 and 13.
Yes.
But the point being made at paragraph 42A was a general point.
So, my Lord, it may well be, and of course I don't concede this in a purely domestic case, but in an international case I would certainly say that the place for where the maintenance creditor is habitually resident has jurisdiction. Of course, I say it's a matter for national law to determine what that court is. Now, in England and Wales, we no longer have territorial courts. There is but one family court. And the family court sitting at the Truro Family Justice Centre is just as much the court for the place where the maintenance creditor is habitually resident as the family court sitting in Newcastle. So the issues of proximity don't arise where national law doesn't have territorial jurisdiction. My understanding is it's different in Scotland. If you don't live within the sheriffdom of the particular court, the local sheriff court doesn't have jurisdiction. We used to have provisions similar to that in relation to the county courts, but of course we only have one county court now as well. If that were right, talking about my Lord Sale's point, clearly there is one High Court for England and Wales and one Family Court for England and Wales. It's not suggested, I don't think it could seriously be suggested, that if one party issued in the High Court first and then another party issued in the Family Court second, that Articles 12 and 13 would prevent, within a territorial unit of the United Kingdom, the court saying, actually, no, this could be in the Family Court or the High Court. So there's a limit, I say, to how much the EU is willing to get involved. And the point I take away from Sanders is it's not easy to understand, But at all points, it says it's a matter for member states as to how they deal with jurisdiction within themselves. And of course, it was, as I think it was eventually conceded by my friend from the Secretary of State, a cross-border case. It was a case where the maintenance regulation was directly applicable because there were international elements to it. The second point I want to make on this issue is that there's no material difference in my submission between the maintenance regulation, where it says jurisdiction shall lie with the court for the place where the maintenance creditor is habitually resident, and the judgments regulation, which says jurisdiction can lie with, in a tort case where the harmful event occurred. And that was exactly the provision that was at place in Cook and Virgin Media, and there was nothing said to be inconsistent with a jurisdictional rule of that nature and the continued existence of forum non-conveniens under the judgments regulation at the EU level. I want to say just one other thing about the elision, as it were, of the choice that an applicant has and the choice that a maintenance creditor has. And that can be seen from the case of R&P. That's Authorities tab 61, volume 5, I'm grateful. And yes, it's paragraph 30, forgive me, at MS 1671. You'll see the provision related, the reference to Article 3, and that offers the party, when he acts as the applicant, possibly bringing his case under that. So the maintenance creditor has a choice, provided they get in first. And we know that there are many jurisdictions which allow a maintenance debtor to ask the court to consider making orders against themselves, and if they do so within the context of divorce and or proceedings relating to parental responsibility, then that choice to the maintenance creditor is denied. It's something that the maintenance debtor can, as it were, steal a march. The maintenance regulation, and indeed our own internal regulations, could have said wherever there is more than one court with jurisdiction, it will be the maintenance creditor's choice, and they don't do so. If I can turn back then to issue 2, and what we say is the purely domestic consideration, the construction of the 2011 regulations. Just to respond to one or two matters, where in our written case we say that that forum non-conveniens was a fundamental part of the pre-existing scheme, that's at paragraph 40, MS 2119. We're not seeking to elevate that to a fundamental human right such as legal professional privilege or the other matters which are referred to in paragraph 29 of the Child Poverty Action Group case. What I say that is clear is that it's common ground that the Child Poverty Action Group case is the guiding authority, but I do say that there are some matters of emphasis that do need to be looked at. I say that the key passage is that at the end of paragraph 34, and that's at MS 337, and that's in the, the primary volume of authorities. Tab 11. And that's opposite letter D, opposite letter E, for instance, and that question is the key question I invite the court to adopt. A help or an aid in answering that question is given in paragraph 33 if the remedies cover the same ground and are inconsistent. Indeed, precisely the same ground and are inconsistent, then the remedy at common law will almost certainly be excluded by necessary implication. I say that 34, opposite letter D, with that help, is a much clearer way than the end of paragraph 31, which my learned friend took you to yesterday. I also say that whether the statutory code is an exclusive one is, in my submission, a conclusion. If you have determined on the construction of the statute that the common law remedy is not incompatible with the scheme and therefore could not be held to coexist with it, you have found that it is not an exclusive code by definition. So it's the answer rather than the question in my submission as to whether it's an exclusive code. And in my submission, I say that the respondent accepted that there was no reason in principle why, however strange or otherwise they may be as bedfellows, why they could not coexist in these circumstances. In relation to the other matter, I made plain yesterday that if it be the case, my primary submission, of course, is that they are not inconsistent. My secondary submission is that Article 13 and Article 13 alone, as it were, is on the same territory, and therefore that any court first seized or any court which is alone seized still has discretion to stay on FNC grounds. The second court would only have the ability to stay on FNC grounds if the actions were unrelated. In relation to that, the maintenance regulation does, as I've already said, refer to the idea of there being no role for national law. My two submissions on that are that that's in the context of disputes with third states. And secondly, if that's the case, then it doesn't make any sense why Article 9 is not incorporated. If Article 9, the definition of when a court is seized, is excluded, the learned friend accepts that we're thrown back onto national law as to what that means. So you can't have your cake and eat it in relation to that. Either you have to go back to national law, in which case it's not a comprehensive code, or you can't. Can I deal with the structural point? It was suggested that maintenance was removed from the 82 Act by the 2011 regulations, and there were the three dots in our copy of the 82 Act in Schedule 4, which we see, give me, at MS 45. My submission is that what was removed from Schedule 4 was not maintenance itself, but the special rule of jurisdiction that applied in maintenance cases. Maintenance, as we set out in our written case at para 56 at 2127, came out of the scheme in Schedule 4 because maintenance was removed at the EU level from the judgment regulation. And that's why we say that Section 16 is nothing to do with the removal of maintenance from the scheme in the 1982 Act. And that's why we say that the words subject to the 2011 regulations must mean something in Section 16.4. And that's why we say the link is still there. again, Section 49 is not a conferring provision, it's a saving provision. In relation to issue 3, ladies and lords, my primary submission is that Section 22B does not allow the executive to reverse a policy decision enshrined in an Act of Parliament. And that's in the context of what Lord Mance was saying at paragraph 59 in Nolan, where the relevant EU regulation or directive expressly requires the reversal of a policy decision in an Act of Parliament. Of course, it must take precedence, and that will happen under Section 22A if regulations are made to that effect. But I submit that the argument in Pothecary might have been very different if Parliament had expressly, on an earlier occasion, considered whether to extend the reversal of the burden of proof to victimisation cases and expressly decided not to do it, or expressly provided that the burden of proof was to remain on the claimant in those cases. My Lord, was not respectfully adopt your point in relation to the transcription note not being accurate in relation to a minor omission or minor exception, and that removing formal nonconvenience was indeed a large step. And given the importance of forum nonconvenience to the earlier scheme, I say that one has to see the size of the step in relation to the importance of what has been taken away, and taken away without any democratic mandate. In relation to issue 4, my Lady Black yesterday asked about the position in relation to Scotland, and I did take the court to paragraph 13 of the judgment of the Court of Appeal, that's at MS 2220. There is further information about the duration of an order for aliment in Scotland in our skeleton argument which was before the Court of Appeal, and that's at MS 2341-2, where Mr. Lang and I set out some information that we had from a Scots lawyer, Mr. Scott Cochrane, who helped us in relation to that. And I don't think that that exposition of the law was seriously in dispute before the Court of Appeal. And that expressly says that an order for aliment made outside matrimonial proceedings in Scotland comes to an end when the decree of divorce becomes effective. Can I deal quickly with N and N? Two things in relation to that. If one looks at the judgment of the court below at MS 2236 and paragraph 74, the court will see that the court below were appearing to limit the consideration by Mr. Justice Moore of Article 13 to Article 13.1, and as we've seen, Article 13.2 was expressly considered. I also take issue with Learned Friend's characterisation of Mr. Justice Moore's analysis as being one of forum non-convenience. He, and one can see this in the same place at 2237, and in particular subparagraph F, where one has the words of what is Article 13.3 throughout subparagraph F at MS 2237, expedient to hear and determine the issues together. There would be a risk of irreconcilable judgments. He's clearly applying, in my submission, Article 13.3 and defining that term. in answer to, or in response to a point made by my Lord Wilson, in relation to the scope of Article 13.2, I don't argue that that is a power that is available if the actions are not related. It's clear from the context of Article 13.2 that in order for that to apply, they must be related. Article 13.1 talks about related actions, and Article 13.2 says these actions. And similarly, the same point would be made about Article 30, subparagraph 1 of the revised or the recast judgment regulation, and that, for the court's reference, is at MS 532. Going to just ask you to look again at section 16.4, going back to the structural issue, as it were, in issue 2. My primary submission is that MS 28, thank you, that there's no need for any reference to Schedule 6 at all in section 16. Once at the EU level, maintenance is carved out of the judgments regulation. But section 16.4 does not limit the operation of section 49. It says the provisions of this section and Schedule 4 take effect subject to the regulation and to Schedule 6. Section 49 is a saving provision that's unaffected. And I say that, again, if that's... if there is any link, as it were, between Schedule 6 and the 82 Act, then Section 49 still remains unaffected. Those are my submissions.
Now, I think we've thrown at everybody all the questions that we can think of. And thank you. You are within time, Mr. Horton, which is good of you. We're grateful to everybody for their submissions in this not uncomplicated case. We're particularly grateful to those who've been acting pro bono in the public interest to enable these important arguments to be properly ventilated. So thank you all very much indeed. We will go away and put wet towels on the back of our necks, try and sort out the answers.